Good morning. My name is Brendan Snowden. I'm the co-chair of Cummings & Lockwood's commercial group. The topic of my presentation is questions to consider when using an LLC. LLCs are used all the time for a variety of purposes. They're used today as opposed to a lot of other options, such as like corporations or partnerships, in large part due to their flexibility and the relative cheapness. Carrying costs for LLCs are very low, depending on the state. You can form an LLC for a couple $100. Again, depending on the state, it can be, I think, the annual maintenance cost for an LLC in New York is $9 every 2 years. The maintenance cost in Connecticut is $0. Given the low carrying costs, low opportunity costs, people will form LLCs in a large variety of situations. The presentation is intended to cover some of the more common purposes we might use an LLC for, and how those purposes can impact the choice of jurisdiction of the formation, the number of members you might want to have for the LLC, the identity of those members, who you want to manage it, including kind of whether you even need an LLC at all. It may be that off-the-shelf, regular, just kind of legal Zoom type LLC will work, but based on what I'm hoping to show you is that a lot of these questions may kind of point you to a more complicated structure or something that you will have to kind of change exactly what the LLC looks like in order for it to do what you want it to do. Some of the common purposes that I'll go over are the big one, limitation on liability. So that's protection of the members' assets against liabilities of the LLC. The inverse of that, which is kind of colloquially called charging order protection, which is protection of the LLC assets against or creditors of the members. Various succession planning issues, and then also privacy considerations. There are other kind of reasons you might want to form an LLC. I'm not going to talk about them here, but centralizing management, economies of scale by packing on a variety of assets in one entity that, especially if they get sizable enough, can provide access to certain investments that you wouldn't otherwise be able to have. Taking advantage of transfer restrictions and statutory transfer restrictions. The inverse of that, ease of transfer. If you put private equity investments in a LLC, it is easier to transfer those interests of the LLC rather than going back to each of the private equity firms and paying them to have to individually transfer those to successors. If I get to it, depending on how fast I will talk, I'll also talk about the Corporate Transparency Act. If not, there are slides at the end that can kind of summarize the basics of what that law is. The most common thing people think about when they think about why you have an LLC is limitation on liability. So by statute, and this is pretty much for all 50 states, the members of an LLC will not be responsible for the debts and liabilities of the LLC. I guess we're talking about the Brady Bunch today. So we'll have a hypothetical auto body shop owned by Mike and Carol. If something happens at the auto body shop, Mike and Carol themselves are not responsible. So that is far and away the most common reason why people form LLCs. This will apply regardless of how the LLC is structured, whether the LLC is owned by Mike and Carol, whether it's owned by Mike, Carol, Greg, Marcia, John, or Jan, all the other kids. I'm neither millennial nor a baby boomer, so I don't exactly know who is with the Brady Bunch. It will also apply if it's just in single member entity standpoint. So if it's just Mike who owns the auto body shop, by statute, there's still liability limitations. So just because an entity is a single member entity, the statutory protections against liability still exist. There are exceptions to this. The biggest one, I think everybody's kind of heard of kind of piercing the corporate veil. But the threshold for piercing corporate veil is pretty high. It requires essentially kind of two things. One is an alter ego determination, which is in essence that there is no real distinction between the LLC and the members. When Mike goes out and does his auto body work, he is representing it in his own capacity. The bank account is the same bank account that's with the family bank account. They use it to pay groceries and so forth. The auto body shop's name isn't used everywhere, et cetera, et cetera. But that's not the only thing that has to happen for a court to pierce the corporate veil and hold members liable for the debts of an LLC. You also need to use the LLC for some sort of fraud. Or it depends on the state. In Connecticut, it has to be kind of a fraud or injustice. Other states, it just has to be kind of an intentional misconduct, which is somewhat lighter standard. But it's not just that you treated the LLC as your own. It's also that you did something bad with it. Those two factors combined with the fact that the person seeking to pierce the veil has the burden of proof means that you can kind of screw up pretty badly in terms of corporate governance and still probably get those protections. Now again, I would much rather be in a situation where the members treated the LLC appropriately, and we'll always advise clients that open up a separate bank account, don't use personal assets of the LLC, or don't use the assets of the LLC for your personal use, et cetera. Those are all, you're not even get to a piercing issue if you do those sort of things. But just because you don't doesn't mean that you're necessarily going to lose those protections. Most statutes will include, including Connecticut and I think New York, provisions that say explicitly that failure to follow corporate formalities does not get rid of the protections on liability. One special New York rule that it's something of a shock to some people is the 10 largest members by ownership are jointly and severally liable for the debts of the LLC with respect to kind of wages and other salaries of those people working in New York. What that means is if you're investing in a private equity firm or something like that works in New York, you're probably okay because you're not going to be one of the 10 largest holders. But if a client comes to you, wants to invest in his friend's restaurant in New York, first question I always ask is, well, how many members are there? What sort of percentage are you going to be at? If you're one of the top 10 holders and that restaurant fails, by statute, you can become jointly and severally liable for any unpaid wages and salaries of the employees and other staff there. The people, the employees who are seeking to kind of get redress through this first have to go to the company, so it really only applies in the case of a liquidation event or a bankruptcy. And they have some pretty tight schedules to do so. They got to jump through a whole bunch of hoops. But then again, some clients aren't really all that comfortable with that sort of risk. And it's something to consider when investing in an LLC. But it's not clear whether an LLC blocker would protect you from that liability. So for instance, if you took advantage of the liability protections of a Delaware LLC to use that Delaware LLC to invest in the New York entity, whether it's an LLC or corporation, whether that will protect you personally from this rule, and it's not really clear. It certainly doesn't hurt, going back to opportunity cost and low setup costs. If the client can afford the few $100s to form an entity and the maintenance cost, depending on where they're located, we would certainly advise them to do so. It's not necessarily going to be a 100% solution. So a couple other ways where the liability protections can break down, and this is where I think the misunderstanding with protections with respect to single-member entities comes into play, is LLCs, they protect members. What I tell clients, going back to Mike's example, Mike, who owns the auto body shop, has on a member hat. He has on a manager hat. He might have an employee type hat on. The LLC protects the members. It doesn't protect him necessarily as an employee. So what that means is, if the auto body shop enters into a contract with a supplier and defaults on the supply contract, the LLC limitations will probably save you. If Mike takes the car out and rear-ends somebody, it's probably not going to help him because he didn't rear-end somebody as the member of the LLC. He did it as Mike Brady driving his car around and not paying attention. The grayer areas are things that are kind of where the hats aren't really all that clear, consulting being one of them. A lot of clients come to us and ask to set up LLCs to perform their consulting services through. Again, low carrying cost doesn't hurt, but depending on the industry, depending on what you do, it may not be a 100% bulletproof solution. Let's say you're responsible for putting together rating agency reports. If you do something bad there, you're probably going to be held personally liable due to your own negligence as the person giving the rating agencies, not necessarily as the contractual party with the rating agency. So next, consideration is what's called charging orders. This is protections of the LLC assets against creditors of the members. So again, let's go back to Mike and Carol. Let's have two owners here. If Mike has a personal creditor, that personal creditor's, in most states, or many states, that personal creditor's redress with respect to the assets of the LLC is limited to basically money coming out of the LLC, so any distributions that might happen to go to Mike. Those creditors cannot go after Mike's interest directly. LLCs kind of stem from partnership law, where the basic tenet is you can pick your own partner. So it's designed to protect the innocent partner. So again, Mike and Carol, Mike has the creditor, Carol doesn't. Carol shouldn't have to be in a situation where now she's having to deal with Mike's creditor. One thing to point out in this presentation is it says New York, it should be Delaware. Connecticut and Delaware limit the redress for creditors just to charging orders. It very much varies state by state. Some states will have the exclusive charging orders. That would be Connecticut is one, Delaware is another. Other states are more forgiving. They will allow not just charging orders, but allow creditors to actually foreclose on an interest, New York being one of them. So if a court determines that it's not going to be sufficient to give redress to the creditor for them just to take the economics out of the LLC, they will allow the creditor to go in and take Mike's actual interest. Thereby, the LLC, which used to be owned by Mike and Carol, is now owned by Mike's creditor and Carol. Other states limit charging orders to multi-member LLCs. For instance, Florida explicitly says that charging orders are not the exclusive remedy for single-member LLCs. So while charging order protection would be the exclusive remedy in Florida for a scenario where you have Mike and Carol, it would not be an exclusive protection for a scenario where it is just Mike. Other states go exactly the opposite and protect even single-member LLCs explicitly. Delaware and Connecticut both do that. Connecticut's done that since the beginning. Connecticut has recently changed its law, I think 2016, to limit the remedies to just to charging orders for even single-member LLCs. So one question that kind of arises is, does it make sense to forum shop? If there are assets of the LLC that you would like to protect against personal creditors, does it make sense to, for instance, let's say the auto body shop is in Florida and Mike is the owner, does it make sense to form the LLC in Delaware and just have it registered to do business in Florida? The answer is maybe, depends on the individual state law. Most states will apply the local law with respect to charging orders. If the entity is registered in Florida, even if it's a Delaware entity, Florida is probably going to apply charging order rules. Where you have assets that do not have requirement to be located in that particular jurisdiction, say rather than an auto body shop that's being operated in Florida, you have just an investment LLC that has a portfolio of securities, yes, you can probably leave it just as a Delaware LLC and still get charging order protection. Other options that people will use to kind of get around this or to get otherwise protected is to take a single-member LLC and make it a multi-member LLC. Downsides of that are a few. Where there are some states, for instance California, that are pretty specific that you have to have a bona fide kind of real interest to do that. You can't just have Mike own 99% of the company and Carol own 1%. It kind of has to be kind of a real parties. Husband and wife at 50-50, maybe that works. Husband and wife at 99-1 probably is not gonna apply. The other way to do it is kind of create a blocker. Again, throwing more LLCs at the problem is have a Florida LLC operated as a single member entity, have that owned by a Delaware LLC, and have the Delaware LLC then owned by the individuals. And again, depending on the type of assets, this might not really be relevant. Are you concerned about individual creditors going after those assets? Take, again, the auto body shop example. Yes, you want to protect the livelihood of Mike and Carol. Charging order protection will be very relevant. If they own an art collection and are housing in an LLC, probably doesn't matter. Because again, the charging order protection will allow the creditors to get after the economics. They just won't allow them to operate the LLC. So you're not going to be able to protect the gains that come from those assets or the economics or the value of those assets. You're just going to be able to protect the use of those assets while they're in the LLC. So next one is succession planning. LLCs are often used to kind of transfer business assets to their kids. So again, Mike and Carol transferring to Greg, Marcia, and Jan. How you set up the LLC can change drastically depending on kind of how many kids you have and in what situation those kids are. I'll go through a few of these questions. First one, if the auto body shop transferred to Greg, Marcia, and Jan, Greg and Marcia actively work in the auto body shop. Jan lives in Wisconsin and doesn't have anything to do with the business. Can Jan transfer to Marcia or Greg without the other one getting a chance to match it? So basically, do right of first refusal rights apply with respect to intra-family transfers? By default, the answer is usually no. But again, if you have a tightly bound family where somebody may have an interest in just getting rid of it, getting rid of their portion, it may be important that Greg, for instance, can't take advantage of the situation by purchasing out Jan, because Jan always hated Marcia. You want to make sure, especially from the parent's standpoint, you want to make sure that the LLC is set up in such a manner that the kids can't take advantage of things kind of going forward. A few other questions: can spouses of the next generation be members? Worst thing could happen is that Greg has to deal with Marcia's ex-spouse. It's not the spouse that's the problem. It's if that spouse becomes an ex-spouse, you don't want them owning the auto body shop. Third one here, estate planning vehicles often are used. So if Jan sets up a trust to hold her interest in the auto body shop, it's always going to be the case where the operating agreement limits the beneficiaries of that trust to just lineal descendants or kind of family. Question is what about trustees? Do the trustees also have to be family? On the one hand, you want to give maximum flexibility for estate planning reasons, so you might want to permit the use of third-party trustees or non-family trustees. On the other hand, going back to kind of you pick your partner, family may not be all that comfortable having to deal with a third-party trustee making decisions with respect to the operation of the business. A few other questions: how are managers determined? While the auto body shop is being ran by Greg and Carol, it'll be managed by Greg and Carol. That's usually pretty standard. But kind of what happens in the next generation? Sometimes it'll just be majority rules. Majority of the kids decide who's going to manage the company. Other times there'll be one designated kind of favorite child. Say Greg is the person that they want to run it no matter what. So that person by the operating agreement will be designated as the designated successor and will not be able to be removed. Other times the operating agreement will provide that each family member can choose their own manager, but kind of like a board of directors as they kind of go forward. If managers kind of control the day-to-day decision making, what sort of decisions have to be determined at the member level? Do you need unanimous consent? Unanimous consent's good because it gets all the family members kind of aligned. It can be bad because, again, if you have disinterested kids or people who are not as involved in whatever business you're talking about, they can certainly have a veto block or veto power. Next one on the list is distributions. This comes most into play where you might have people with different economic backgrounds or different economic situations. The biggest one that often this comes up in is real estate. Say you have a commercial real estate portfolio where one of the kids runs the portfolio. They get management fees. They're getting paid already. The other kid has nothing to do with the business. It's been given down from their parents. If you don't have a mandatory or excess cash flow distribution provision in there, they're probably never going to get paid. And that can kind of have some messy family dynamics. Tax distribution, similar thing, phantom taxes. If everybody can't pay for their taxes themselves and need mandatory tax distributions, you want to make sure that those get in an operating agreement. Capital calls, inverse of that. Who gets to decide capital calls? Are they capped? What happens if one or more kids can't meet the capital calls? Are they diluted? Are they diluted just from economics? Are they also diluted from voting? And then lastly, kind of exit rights. So how can kids get out? Do you give them the right to kind of put their options to the other children who might want the business? Are you in it for the long haul until a majority of the kids decide to sell? Again, just kind of depends on the individual situation of the family. Lastly, privacy. So this doesn't happen all that much anymore, especially with a lot of the changes in disclosures for other reasons. But a lot of times clients will come to us and ask to set up an LLC, especially in the real estate context, to have the real property owned by an LLC for privacy reasons. That works in some states and works in others, and it largely depends on what the individual state requires to be disclosed with respect to that LLC. Delaware, the only thing you got to disclose in Delaware is a name and a registered agent. No one actually lives in Delaware, so the registered agent is going to be a third-party company in Delaware. So full protections from privacy there. New York is also pretty good. You need to have a company address in New York, but it can also be a third-party address. It does not have to be a business address. Most other states require a lot more information about the members and managers of the company than people are comfortable with. Connecticut and Florida especially, you need business and mailing addresses of the company. Those you could probably kind of get around in terms of privacy issues, but the ones you can't is you need the name and address of at least one member or manager. And that's usually a pretty heavy kind of burden to get over. I don't think this is the case anymore because we changed it, but I used to always tell clients that I knew what the house of our chairman of the board looked like because I could look it up on the Connecticut website. So I don't know if Laura's still here, but I don't think you can do that anymore. You can find personal addresses in Connecticut and Florida. Other states like Massachusetts, Maryland's another, that's going to be especially complicated because you actually need a physical address in the state to form an LLC there. Lastly, if you're forming an LLC to own real estate and the real estate is going to be rented, if it's just going to be owned, just a pure vacation home, you can form a Delaware LLC to own, say, a Connecticut property, and you're probably okay. If you're going to rent the Connecticut property, it is going to be considered doing business in Connecticut, therefore it needs to register in Connecticut. So you're back in the same situation anyway, where you're listing members and managers on a public website. Furthermore, even if you're not doing business, and it's kind of a crapshoot, but some utilities, some banks will require the LLC to be registered in the state. So it's not a statutory requirement. It's pretty clear that owning property without more is not doing business in Connecticut. But we've certainly had situations where we've done this. We formed a Delaware LLC to own Connecticut property. Everything's fine until the client tries to hook up the gas, and the gas company says, well, you're not registered in Connecticut. And there, the company either needs to register in Connecticut, or you got to do some more hoops where you basically have the family rent, and you're going to have to do this anyway, but you're going to have the family rent the property from the LLC, and therefore that the family members are the ones that are hooking up the gas, not the LLC. I think I'm over time, so I won't talk about the Corporate Transparency Act here. There are notes on it, but in essence what this is a new requirement for anti-corruption reasons. New companies starting in 2024, all existing companies starting in 2025, so that's everything that's been created since the dawn of time, are going to have to register their significant beneficial ownership with FinCEN. That's going to be a pretty massive undertaking. Good thing is we have a year or two to kind of everybody to figure it out. The other good thing is it is not a public database. The only use of this database will be is for law enforcement purposes. It's not going to be publicly available for everybody to use.